Welcome everyone to a new edition of Workplace Wednesday. I'm Nicola Martin, partner in the Labour and Employment team in Sydney here at Squire Patton Boggs. Today I'm going to talk about the recent High Court decisions in two major test cases regarding the determination of employment versus independent contractor status. The cases are the CFMEU against Personnel Contracting, Pty Limited, and ZG Operations Australia Pty Limited against Jamsec. In the Jamsec case, historically the respondents had been employed drivers for a company. Many years previously, the company had advised the two drivers that it couldn't employ them anymore, and if they wanted to keep driving for the company, they'd have to become contractors. The drivers set up partnerships with their spouses, bought their own trucks, signed contractor agreements, and invoiced the company for deliveries. Years later, the drivers started proceedings against the company on the basis that they had been employees all along, despite the contractor agreement they signed. So what did the High Court decide? It decided that the drivers were contractors, not employees. Why was that? The court looked at the facts based on the rights and the duties of the parties as set out in the agreement signed between them. Nothing in the agreement suggested the drivers were employees of the company. The drivers were free to do work for others if they so choose, and they took advantage of their business partnership to split income and tax, as well as claiming costs. In the personnel contracting case, the High Court was assessing the working arrangements between a labour hire agency, a client and a worker. Personnel Contracting, which was trading as Construct, is a labour hire company who supplies labourers to building company clients. Construct entered into a contractor agreement with a backpacker, Mr McCourt, for Mr McCourt to be a self-employed contractor. Construct and a client, a builder, contracted with each other under a labour hire agreement. McCourt did not contract directly with the builder. McCourt worked under the supervision and direction of the builder. Construct never directed McCourt in the performance of his work. Proceedings were brought against Construct for the payment of employee entitlements. What did the High Court decide? They decided that McCourt was found to be an employee, not a contractor. Why? Because both parties accepted the contract was wholly in writing. There was no suggestion that the terms of the contract had been varied or invalidated by the conduct of the parties or were otherwise a sham. In these circumstances, the court said that the nature of the relationship was defined by the legal rights and obligations set out in the written terms. Under the contract, McCourt only provided labour. He couldn't subcontract the work to anyone else, and the builder had a significant degree of control over McCourt's performance, to the extent that he could not be seen to be independent. As a result of the High Court's reasoning in Jamsec and Personal Contracting, the following 5 considerations now arise when determining the true nature of an arrangement to perform work. Firstly, the reliance on the contract's terms. Where an arrangement is properly documented, courts are now required to have primary regard to the written terms of the contract and the rights and duties arising under those terms, and there's only limited exceptions to that. Secondly, labels are not determinative. Simply labelling an individual as a contractor will not be determinative of the relationship. The whole of the written terms need to be considered. Thirdly, there's examination at the time of contracting. Events and circumstances surrounding the contract which are known to the parties at the time of contracting may be examined in seeking to identify the purpose or the object of the contract. However, subsequent conduct will generally now not be relevant to the task of characterising the relationship between the parties, and this is a significant departure from the way in which the courts have been determining worker status for many years. Fourthly, subcontracting labour hire providers take note. The personnel contracting decision demonstrates that labour hire providers can be determined to be employers despite purporting to engage workers as independent contractors. And fifthly, contracting with entities. The decision in Jamsec reinforces the position that workers operating through partnerships or other corporate entities who structure their tax arrangements consistent with their claim status as contractors are even less likely to be considered employees. So the takeaways, it's now more important than ever that you ensure your independent contractor agreements are reviewed given the vital importance of the written terms. We'll be discussing both these cases in further detail and talking more about the practical implications and what you can do to protect your organisation at an upcoming webinar on the 24th of March. Registration details follow on the slide. Thanks so much for joining me today, and I look forward to seeing you again next month for another edition of Workplace Wednesday.